Well, the thing about this case is that it is such uncharted territories. And I think that this has been a theme for the administration. They're really pushing authorities in the trade space beyond what they have been used for before. This was true in the first Trump administration, and it's true now. And that really makes the outcomes of these cases a bit unpredictable, which is maybe why we see such surprise today of the outcome that came out of the CIT. But there's going to be a lot of twists and turns to come with the motions for stays to hold the order, both at the lower court, also at the Court of Appeals, potentially going to the Supreme Court tomorrow. I think we don't know where this path is going to take us, but I think there's going to be twists and turns along the way.
Well, isn't part of the story here, Greta, that nothing actually is going to change? If this White House is seeking a stay, then pretty much everything stays in place. You add Section 122, Section 232. We're all apparently experts on this stuff now, that the White House feels like it has a pretty strong hand beyond the emergency argument, that when it just comes to basic procedure, they're going to keep doing what they're doing.
I think that's right. I think that's what you heard from Peter Navarro. I think that would be consistent with the direction of the president's given and the importance he's put on this policy and the reasons behind it. So whether they prevail in the courts and are able to keep these tariffs in place, or if they have to look to another tool like Section 122, we just keep adding numbers to our number basket for tariffs. Yes, I think that you would say there's likely to be a continuation of this policy in one form or another.
So does it become then just a question of the timing it actually takes to enact the policy, Greta? Because if you need full investigations in order to use some of these authorities, that would suggest that he can't necessarily find ways to reimpose tariffs on trading partners by July 9th, for example, when the deadline for negotiations on trade deals is supposed to be.
Right. Well, every trade authority has pluses and minuses. And IEPA, the authority that has been, its use has been struck down, it's very flexible and very fast. And so that made it very attractive for the administration to use. And other authorities do have drawbacks. Some of them, as you say, require investigation. That's the case with Section 232, these sector-specific tariffs like steel, aluminum, autos, and there's a number of other ongoing investigations. That's true of Section 301, which is the authority that was used to put tariffs on China in the first Trump administration. Now, there's a new authority that was actually cited in the case in the order pausing or invalidating the IEPA tariffs, 122. This is a balance of payments, balance of trade authority that hasn't been used before, doesn't require an investigation. So that could go on pretty quickly. Now, the downside there is it only lasts for 150 days, and you can only go up to 15% in the tariff level. So again, drawbacks, you have speed without authority, but there's limitations on its use.
Much has been made, Greta, of the fact that we got a ruling from judges appointed by Barack Obama, Donald Trump himself, and Ronald Reagan. And I want to turn you into a legal analyst for the purposes of this conversation, but how are you reading into that?
I don't read too much into it. It's the Court of International Trade. These are experts on trade authorities. They come at it from a particular perspective. They've dealt with many of these authorities many times and thought about the delegation of tariff authority from Congress to the executive branch and what the contours of that may be. I mean, I think it's more about, to me, this court and how it thinks about these authorities than maybe the particular people who were on the panel in this case.
What do you think this means, Greta, for negotiations that are still ongoing between the U.S. and trading partners? Is there a material amount of leverage lost here if Trump and his proxies in the administration who are negotiating on his behalf can't say, look, if you don't agree to this, we're just slapping X tariff on you? If they don't necessarily have that power because the courts have said that they don't, does that substantially weaken the United States' hand?
I don't view it necessarily as a big change. And there's two things going on. One, for example, for the UK, the concessions they received were around not the tariffs that have been struck down yesterday, but around the 232 tariffs on autos, on steel, aluminum, on a potential pharmaceutical tariff action. And so many countries are still interested in those tariffs. And then again, I think there is the prospect of the administration using other tools to impose tariffs. And it's not just 122 and these 10 or 15% tariffs, but could they launch a Section 301 investigation with respect to particular countries and put in place the prospect of even higher tariffs? It's a possibility. And so, I think that trading partners are going to take a beat to assess the situation, what they're hearing from the administration, from Peter Navarro today, from the press secretary, from the president himself. But I think they're going to probably take the view that the administration, the president's going to continue to pursue this policy, and that they're going to have to operate under those parameters.
This is a court that not many people had ever heard of, I think, before this story. When you're working in the office of the U.S. Trade Representative, how often are you interacting with the CIT, the Court of International Trade?
Well, it is the court that the trade agencies interact with. So any statute, so for example, Section 301, it's another tariff statute. There has been litigation ongoing since the first Trump administration, was ongoing when I was at the U.S. Trade Representative's office that was before the CIT. And it is that court of first instance that every tariff action goes to. So for those in the trade sphere, it's not obscure. It's where all of our cases and controversies funnel through.
And finally, Greta, we just have a minute left here, but knowing President Trump in recent weeks has said if negotiations with partners don't go well, that the U.S. is just going to set a tariff rate, tell countries what it costs to do business with the United States. Unless he pursues one of these other authorities, should we assume that he, in fact, isn't going to be able to do that in these weeks, that he won't have the authority to do so?
Well, it may be difficult for him to do so. There is an even more obscure statute called Section 338, which also has not been used and has been, it talks about unfair practices, discrimination. That's another potential tool. There's a lot of questions about the process to invoke it. So, never say never, but it will certainly be a challenge. And the president and the administration may need to jump through some hoops, do some work to fulfill the requirements of these statutes in order to follow through with that. But again, I think that the specter of higher tariffs, can be put in place immediately, even if it ends up being delayed in impact.